We're going to talk about exceptional hardship in penalty points cases. Now, an exceptional hardship argument is a way that a driver who gets 12 or more penalty points can sometimes keep their driving licence. So the normal consequence of getting 12 penalty points in England and Wales, most of the UK, is that you must be disqualified for at least 6 months. It's a minimum disqualification of 6 months. But if the driver can establish that they will suffer exceptional hardship or somebody else will suffer exceptional hardship, then they could keep their licence. So an example might be a driver's got 3 fixed penalties on their licence for 3 speeding offences. Then they get a 4th speeding offence come through in the post. That's going to take them up to 12 points, so 3 points for each one. Then they're going to have to go to court. They face a 6-month disqualification from driving, but if they can show exceptional hardship, then they may well avoid a disqualification altogether. All the exceptional hardship does is it means that the court don't have to disqualify for the minimum of 6 months anymore. But usually, the courts, when they find exceptional hardship, tend not to disqualify at all. Although they do have the option of giving a disqualification shorter than 6 months. Now, the definition of exceptional hardship is that it must be exceptional. It seems a strange definition, but it's got to. But what it means, it must be truly exceptional. So, if a disqualification from driving is going to cause inconvenience, or it's just going to cause ordinary hardship, then that's not enough. So, courts will say that doesn't meet the criteria, and so the 6 month you're going to get the 6-month ban. So, it's got to be something out of the ordinary. Now, things like your daily commute going up from an hour to 2 or 3 hours, that's probably not going to be enough for exceptional hardship. Also, courts will quite often say that just losing your job isn't enough on its own to establish exceptional hardship. So they're usually looking for something a bit more than just losing your job. So, for example, an example of an exceptional hardship case might be you're going to lose your job, you'll be unable to afford to pay your mortgage, and you might lose your home. Or you're going to lose your job and you've got 2 or 3 children and you'll be unable to support your family. Some other sort of work-related examples might be that if you lose if you own your own business, you lose your license, the business won't be able to carry on because you're going out doing all the sales work, and some of your employees might get made redundant. So exceptional hardship to your employees would be a good example. Other cases tend to revolve around people who have caring responsibilities. So if you've got caring responsibilities for somebody who's disabled or an elderly relative, something along those lines, and that they can only be done using the car, then the courts might find that exceptional hardship to them is enough to allow you to keep your license. There are all sorts of other possibilities. Those aren't the only possibilities. There are lots of other ones, and courts have found exceptional hardship in all kinds of circumstances. But those are perhaps the main ones: losing your job and losing your livelihood, unable to support your family, and being unable to support people who you have to drive around. Now, the courts tend to say quite often that exceptional hardship to other people is more attractive. So if there is somebody else who's going to suffer exceptional hardship, that somebody else has done nothing wrong, and so very often the courts will be much more sympathetic to arguments exceptional hardship to third parties. Now, just one procedural thing, and there are a number of different procedural things, but the most important procedural point about exceptional hardship is that it's got to be dealt with in court. So first thing is only a court can disqualify somebody. So the police can't disqualify somebody with penalty points. The case has to go to court. But if you want to argue exceptional hardship, then you've got to go along to court. You actually have to be there in court to make the argument and to provide some evidence to the magistrate. So there's no point in writing a letter saying I'll suffer exceptional hardship. That won't work. The last point I'm going to make is that exceptional hardship only works in penalty points cases. So, for example, somebody who goes to court and gets done for drink driving, there's a minimum ban of 12 months for drink driving. There's no point in making an exceptional hardship argument in that kind of case. It won't work. It only applies in cases where somebody gets up to 12 points.